Now, the strand that ties together the work that we do, as I've said, is that we feel that we need to put our resources at the disposal of the people in these communities who've been damaged and injured. Now, I totally accept the point that Paul partly made reference to, is that in many ways these cases would be much better dealt with in the home country. I think without question, the claimants in these cases, when they've been injured, when they've been damaged, but having a case that is brought thousands of miles away is not ideal by any means. For them, and also it's not ideal not just for them as individuals because they can't go to the courts, mostly they can't go to the court process, and it seems a very remote process, and therefore that they're removed from what's going on, but also in terms of their own local society to understand the damage that has happened much better, that the case is brought locally, and therefore the legal system can learn, the political system can learn, and the society at large can learn about the mistakes that have been made to allow that to happen. But the reality is that so seldom do we have systems around the world that can actually cope with these cases. And if you look at what a system needs, you start to understand why. Virtually every place that we ever go to, and I presume the same is true with Paul in his work, is that when an instance happens sometimes years before, you hardly ever get a situation where local lawyers have started to act for the injured or the damaged people. And that is mainly because in virtually every legal system throughout the world, to go to a lawyer, you have to pay. And the vast majority of the people who are injured and lose out in these instances simply cannot afford to pay. So unless you have a system that allows for people to come forward and get legal assistance without payment, you have basically no case. Now, through the contingency system in the US, through our no-win, no-fee system in the UK, we've been able to get over that hurdle, and it's a very significant hurdle to overcome. And the UK, the conditional fee system, which has been around for the last 10 or 15 years, has in many ways been a godsend for this. Is in the old days of getting legal aid and banging your head against the bureaucratic Kafkaesque walls of the Legal Services Commission as you tried for year after year to get legal aid, much better now that we can make our own decisions as to whether we as a firm are prepared to put our resources into supporting the communities to put forward their cases to make sure that they're brought in a proper way. The second hurdle that many of these cases face is legal systems that simply don't work. Is that even in Europe, very few systems are able to cope with a case where you get hundreds, if not thousands, of claimants all coming together. When so often in a system you get each case has to be issued separately, each case has to be pursued separately, which when you're talking about hundreds, if not thousands of people, just doesn't work. In the UK, over many years, we've been able to develop a group action system which has worked extremely well and withstood the test of time in terms of ensuring that we're in a position to press cases forward speedily. On Tuesday of this coming week, we're in court with Freshfields, our opposition, the law firm in opposition in terms of the BP case. There we have around about 100 claimants. We will be looking there to choose somewhere between half a dozen and a dozen lead cases that will basically test the issues in the group as a whole. Now, it doesn't matter whether you've got 100, 10,000, 1,000. The principle is the same, that in the end, you look to choose a number of cases that exemplify the group, try those cases, and that the overall position is resolved. It's a good system and it's worked well in the UK, but there are few other systems in the world that do work in that same way. The fact is that in the Trafigura case that was mentioned here, between us and the McFarlane's team that are over here in the corner, we actually worked to be able to actually get the case from beginning to end in three years, which in legal terms is lightning speed. It's a very good system for encouraging the process to get towards trial, to reach resolution. Now, that is a good system, and it means that you actually ensure that rather than allowing delay, which is usually of benefit to the defendants, very rarely of benefit to the claimants, by giving this weapons in terms of allowing law firms to act in the way that we can in the UK and the US, by having a legal system that encourages speed towards trial, those are weapons that are good for the claimants. And what is one of the great worries that I have in terms of the work that John Ruggie is doing that was mentioned earlier, the chap from the UN, is that in terms of pressing for change, which I'm very big supporter of what he's doing, is that there's so many hurdles to overcome. As I said earlier, the fact that there are so few lawyers in this world who are prepared to get out there, even with our own system, which, as I say, in many ways is quite advantageous in terms of what's going on. When we get called up to go and to look at a particular area of work, we hardly ever are in a position where we fall over other British lawyers doing the same. So it's not as though we are in a position that there is a massive amount of interest in this field, even in a jurisdiction that is reasonably beneficial in terms of bringing these sorts of cases. And I think Paul was saying the same to me earlier, that, again, he's rarely in that position from the US. So the sad thing, I think, about the system, and in terms of bringing justice for people in the developing world in particular, in terms of the operations of multinationals, is how few lawyers there are who are prepared to get out there, how few lawyers are prepared to put the resource of their own practices on the line, which you obviously have to do if you're going to get anywhere with these cases. Now, the final conclusion for me is that I think, for me, a civilized society is about giving the weaponry to the citizen if they believe that they've been wronged, to ensure that they at least have the opportunity to have the battle. When Sarah was mentioning the history of the firm a bit, and I think one of the things that happened very early in my working life when we set up the new firm in the mid-1980s is that we had a battle in a case called the Merlins, where there was a family who took on the British nuclear industry in relation to radiation that was getting into their house from the Sellafield plant. And I remember so vividly in my mind that there was something like, we had a team of 4 lawyers, barristers and solicitors, and we were up against a team of around 20. And we got absolutely whooped. And it was a total lesson to me that in the end, if you're going to take on BP, Shell, if you're going to take on Trafigura, if you're going to take on any of these multinationals, to simply get into the court and be in a position where you can at least have a fighting chance to win, you've got to have the resources behind the case. You've got to be able to match the experts that they put forward. You've got to be able to match the scale of the legal team that they put forward. You cannot simply go in on a wing and a prayer. And that is what I would like to see more of in this country. Obviously, in terms of the United States, more members of Paul's PES team that are keen to turn out and support and also be with us. And hopefully there are people amongst you today who are enthusiastic to take that action. Thank you very much.